Our next presenter is Erin McClarty. She is a writer, a creator, a business owner, an attorney by trade, and founder of Erin McClarty PLLC. Erin helps clients all over the world create the worlds they want to live in by working with businesses, charities, institutions, and movement leaders to form structures, documents, and business models that reflect their values, dreams, purpose, and mission. It is my pleasure to introduce Erin McClarty and her session, Reviewing Contracts for Coronavirus, where we will learn to better understand our contracts and how to mitigate risk as the pandemic and landscape shifts continue. Take it from here, Erin.
Thank you so much. I appreciate everyone's patience. Technology for me is interesting right now. But as mentioned, I love the comments because we will actually be going into some of what you all mentioned here in terms of things to be thinking about with your contracts. So I'll go straight into it. Let's see. All right, so I won't, the introduction was illustrious. I won't spend too much time on that other than to say that I am a social impact architect. However, I started out as corporate counsel, so dealt extensively with some of the things that we're going to be talking about today, both for large nonprofits, Fortune 500 companies, smaller geoseismic privately held companies, and now small businesses with the work that I do now. So my hope is to approach this from a variety of different lenses, knowing that there may be different size organizations that are involved with the chapter. And so to that point, in terms of my intentions, the intention is to generally cover the landscape and typical contract provisions and things to be thinking about. All this to say, it is about awareness and building our muscles around contracts than definitive solutions and answers. I know the dreaded answer really that comes from attorneys is it depends, but it actually does depend. So you're going to be seeing a lot of that, and it's not to say that there isn't an answer. It's just to say that the circumstances can change depending on the facts. And so I'm trying to accommodate for that as I go through everything. We'll also talk about risks and the current climate, as was mentioned. So I got 4 slides in before busting out the obligatory disclaimer, which is pretty good for an attorney. But I do want it to be clear. 1, the presentation does not create an attorney-client privilege. What does that mean? I love hypotheticals. They're incredibly helpful for the group. However, just take care. If your hypothetical may make you feel like you probably shouldn't have shared it later on today, then maybe we don't share that. And we can get you to a resource that might be able to help answer that hypothetical question. To that end, I say that because no privilege or confidentiality is created. And again, circumstances are fact specific. It really just depends on the state and the country, municipality even sometimes. So if it's a little too in the weeds, I'll probably suggest that you go to local counsel. And the logistics, from my understanding, we have the wonderful Leah who's going to be looking in the chat to see if there's any questions from anyone, or we'll be perusing to see if there's questions from anyone. Please don't hesitate to ask. There is, of course, nothing too small. If there's a concept that doesn't make sense that I've kind of flown through, then let us know. And I'm happy to try to give examples of what may work. Also, if you have a contract in front of you, you may not, since you just got through doing yoga. But if you do, then feel free to grab it, and you might reference that as you go along. So let's just dive into the current contract climate. As you can imagine, it's a lot. There's so many different complications. One, to the point of the earlier conversation, is just this whole force majeure thing. When does force majeure apply? How are we going to manage it when we have so many different reopening and opening and closing procedures? And that matters because oftentimes when there's a disaster call, when states uniformly say, usually when there is a legislative body, government body, that says, all right, there's a problem, you can typically use that to benchmark the start of a force majeure. When you had countries like Italy, when you have places like Hong Kong, who had a very uniform approach to that, it's a little bit easier in terms of getting an understanding of when the disaster applies. Here, because each state had its own opening and closing procedures, that's going to be a little bit trickier. And really just taking a step back, why does force majeure even matter? What is a force majeure? The best way to think about it is kind of a getting out of jail free card, sorta. So if I can't perform a contract the way that I have agreed I would perform a contract in the agreement, then technically that is a breach. And there could be a number of reasons why, but technically, just at that level, it's a breach of contract. What a force majeure does, it says, all right, if there's certain events or circumstances iterated in that actual provision or that fall under that provision, you may not be in breach after all. And so that's why, to the point earlier, there's just all of this talk about force majeure provisions. Is for a lot of people, it's going to be, or hopefully will be, their get out of free card. But there's a lot of complication there. There's a lot of nuance also with just dealing with contractual defenses. There's a couple of defenses to not being able to perform, like impracticability, impossibility, frustration of purpose, illegality of performance is another one. And so when I say defense, what that means is, yes, you may be in breach because you weren't able to perform on a contract the way that you said that you would. That could be hosting an event. It could be a service you're providing. However, there is a defense to you not performing. And for that reason, you may be able to avoid liability, or you may be able to substantially limit and mitigate your liability. So for example, when you have the closures, the illegality of performance may come in. If I was told I had to close my business, then I might not have been able to manufacture whatever widget for you. And had I continued to operate, I would have been in violation of law. So that may be a defense to a breach of contract in that I didn't deliver these widgets to you by whatever date I was supposed to deliver them. And of course, the courts being closed is making it a little bit more difficult because normally we have them open to help walk us through these processes. Something else we'll have to be working through is who should bear risk, and handling situations with high risk populations like the elderly, children and things like that. It's going to take a really long time, in summary, for us to figure this out. And by that, I mean, it will be years before we get some answers to how all of this will work out, which is why awareness is going to be really key. And by awareness, I mean getting really clear on what your existing risks may be. So when we talk about what are my risks, what should I be thinking about, it's really important that you get an understanding by lasering into what your risks may be, and also panning out, thinking across business lines and thinking across operations. The best way to do that is really going to be gathering your operational stakeholders, gathering your templates, looking at the various pieces of your business, and then also just panning out to think about the bigger picture. And when I say bigger picture, I mean subcontractor agreements. Is that something that I need to be thinking about? I may have had a certain template or language that I use with a client, and then I subcontracted some of that work. Did I take on risk from the client that I didn't actually pass down to my subcontractor that I'm now going to have to pick up? What do my finance agreements say if we took out debt? There's covenants oftentimes that have very specific language that gets kicked in situations, or kicks in, doesn't get kicked in, kicks in during situations like this. So what else outside of just purely my client relationships should I be thinking about? And to elucidate some of this, what I wanted to do was break down each one of these and talk a little bit more. And so when I say panning out, a lot of times we tend to focus on the service that we provide or the products that we provide. So we often focus on the clients, our clients, which is important. But other people that we need to be thinking about, and other people we need to be thinking about, is the supply chain, our vendors, our independent contractors. Are we part of joint venture arrangements and partnerships that we need to be thinking of? And is there language in those or obligations in those that we need to be looking at? Of course, the client, lenders and creditors, as I mentioned, and also just your employees. You know, there's been so many changes around the tax law, benefits, and things like that, that it's going to be really important to see what your obligations were in terms of those things in the contracts that you actually signed. You also want to look at your templates. You know, what do you currently cover? What don't you cover? What are the gaps and the missing provisions? There's no better time to figure out how to rewrite your contracts than to be thinking about what your risks are, looking in your contracts to see if you've addressed those risks and saying, you know what, we didn't talk about this, that, and the other. And when you determine what this, that, and the other are, what are your biggest exposures, and are there provisions that are subject to misinterpretation because they're so vague? And in terms of your risk analysis, the last thing I'll say here is that you have to have direction. Pulling out your contracts and just reviewing them for the sake of reviewing them isn't going to be enough. What is, to what end is what I used to ask my clients. To what end are we thinking about this? Are we concerned about a loss of key relationships? Are we concerned about a reputation, monetary damages? It's really important to be thinking about this because this is going to guide what you look at and how you look at it. It also helps you get a hold of what these amounts are going to look like. That's damage valuation. I won't spend too much time on it, but that's also going to be centered around what you have identified or think your biggest risks are. And then once you look into what the biggest risks are and have a handle on the amounts, looking at, do we have contractual defenses that are available to us, like the impracticability or illegality? Is there insurance coverage? So even if we are responsible, worst case, we come out of that insurance. And people tend to forget that contracts aren't static documents, they're living documents. And so even if we have really crummy risk right now, or we have crummy language right now, there's a way to put a fence around the risk even today. And we're going to talk about, possibility of renegotiating and things like that. So what are ways that we can be doing that? I'll just run through some standard contract provisions really quickly and then take some questions if we have them right after this. But again, disclaimer, keep in mind, it could change, right? So the titles may be different in terms of what you call these things. And I'm not saying that these absolutely have to be in your agreement. I typically see them. So whether or not to renegotiate and add them is going to be something that is up to you completely, but something that I have to say. So the first thing, if you want to see, do I even have an issue? Look to see what your scope is. You would be surprised how often clients worry. And then we look at the scope and we see that either it was so specific that what they were worried about wasn't covered, or it was so vague that it was, and that worked out for them because they wanted to make sure they had terms to cover it. So pay attention to your scope and also carry lessons. Clients tend to love very, very specific terms just in case they don't want to do something or move forward with something. It gives them a little bit more flexibility, where service providers usually love vague because they want everything possible to be covered by those terms, especially if they're wanting to make sure that they don't have out-of-pocket expenses. Not always the case, but it's something that I have noticed. So look at your scope if you want to see, do we even have an issue in terms of this contract? Then look at your warranty. This is where you look if you want to see what, I realize I can't perform in the way that I thought that I could or the way that I told them that I would. So what warranty did I make? What representations did I make? And what disclaimers did I make? This is important because oftentimes in warranty, we say we'll use specific types of products, we'll use specific types of equipment, or we'll have specific types of people that we work with. And so if you've made these representations, you want to be clear on that so that you can try to renegotiate around them if you need to. But again, you may not. You may have left the language very vague, in which case you can make replacements, go with a cheaper option, as long as it performs the way that it said it was going to perform. So be looking at that. And then also just see if can we make changes? Do we have something around changes and modifications in the agreement? And if so, who has to request them? Do they have to be approved? Is that something that has to be requested in writing in a certain amount of days? What's the process look like for that? This is great if you want to stay in the agreement, but you're not entirely sure you can do it the way that you've agreed to. And so we want to start making some changes to it to adapt to the new environment. Pricing and payment is where you're going to look if you want to see, what are my financial obligations? What are they now? And what might they be if the contract ends or terminates? For those who agreed to milestones based on dates, it can be really tricky when stuff like this happens, because what may end up really being an issue is the deliverable that you'll get back may not reflect how much you've paid. And so it may be worthwhile for you to stay in the contract, give it a little bit of time with the delay, to make sure that you get something that's commensurate with how much you've paid. Reciprocally, if you were someone who maybe your payments are heavy at the end, but you didn't get that much payment to start, this may be, again, when you want to look at where are the changes and modifications. Is that something that I can change to make sure this is fair so that I'm not coming out of pocket so significantly in the beginning because I didn't anticipate a viral pandemic to hit when I signed this contract? Limitation of liability and liability, of course, are going to be big, big, big. One, what liability did we specifically say we were going to take on? Really important when we talk about people possibly contracting COVID, because oftentimes it will say, we agree to indemnify, defend, and hold harmless against any body injury, illness, or sickness sometimes. And who is it that says that they'll take that liability? Is it myself? So am I responsible if my people get sick? Or is that something that I can go against the other party for? And indirect damages. Things like loss of contracts. If I can't get the widget to you and you lose major contract with, PCMA because you couldn't get them their mugs like they were supposed to get for their conference, am I responsible for that loss of contract? That would be something that would be outlined in something usually it's called consequential damages, indirect damages. But that's something that you want to look at because that's a biggie. And then, of course, let's say worst case we do have some liability. What's the limitation? Is that something that's capped? Is something we're going to look at. And then, of course, term, breach, and termination. What does it look like if I can't get out of the contract? Can I get out the contract? Etc. Let's see if there's anything else here. No, I think that's it. Oh, and also, can I terminate? And if I do terminate without a breach, what does that look like? Am I going to have to pay out of pocket? Is there an early termination fee? Do I have to send written notice? If so, how many days advance notice do I have to send, etc. I'll also want to be looking at delays and standby and cancellation provisions. You tend to see this in event contracts, some form of it, whether it be cancellation or delays, not always. And if that's the case, even better. You may end up looking at some of the other provisions, but what you want to do here is see, are delays allowed? If they are, is it indefinite? Do we have a certain amount of days that we have to wait for the delay? Are there rights? Do I get paid standby if we're on a delay? If someone cancels, what's that process? Are there extra fees that they have to pay? So again, just really understanding what may we have to do to come out, what may we have to come out of pocket with if we cancel, what am I entitled to if I have to cancel? And if I'm a service provider, I may not want to be on standby for 6 months, so what does that process look like? If we have an indefinite standby or delay provision, then I may want to start looking at termination and all of that to see, is there a way for me to terminate this early? Dispute resolution is going to be important just in terms of understanding your risks around what law applies, what defenses you may have under that specific law. It may not be the same as a law of which your principal business or headquarter is in, what laws govern the contract. Also, if you agree to something like New York law, then what could be tricky then is, I'm trying to think of an example. I had a client recently. So she inadvertently, but nonetheless, signed a contract where the law was US, but it could be litigated in Tanzania. Really long story. And so what ended up happening was we settled out, but she had to hire an attorney in Tanzania that was familiar with Tanzanian law. She had to have an attorney here. And so that's going to be something else you want to look at in terms of your risk is, where is it that we would have to litigate the agreement? Oh, and in terms of risks, is it litigation? Is it mediation first? Do we have to go through arbitration, which can be a little bit more expensive? And so that's going to be something else that you want to look out for. And then mitigation, of course, thinking about what are the ways that we may have to cover losses so that we can file for a claim later on. This is really big for insurance. I won't spend too much time on that. And we talked about force majeure. Is it comprehensive? Does it list what events constitute as a force majeure? Some are very specific and they'll say, acts of God, fire, pandemics. Others will just say any and everything outside of the party's control. If you have a list and pandemics or epidemics aren't listed, that could be problematic. So you want to be aware of that. That may be, again, I don't have this as an out if I'm not able to perform. And then contract administration is pretty straightforward. Biggest things you want to be thinking about is, third-party beneficiary. What that means is they're the two parties that have signed the contract, but there may be parties outside of those parties that can enforce the agreement, which can be really tricky. So you want to see, I may not have a responsibility to the other party, but are there other parties outside of that I may have a responsibility to that I need to be thinking about? I don't think we have any questions yet, so I'll just keep going. In terms of managing your contracts, keep in mind, it's all about relationships, and now is not the time to be a booger. And I bring this up because what I've noticed a lot of people tend to do is they get very adversarial and all Judge Judy when things like this start to happen. But I can't tell you how many contracts I've managed to renegotiate that people did not think could be renegotiated simply because I had a great relationship with the other party and they understood that the situation we were in was maybe outside of our control. It wouldn't have been fair to us. And they knew that if they were in a similar situation, we would have reciprocated. So keep and build those relationships while having the difficult conversations. And don't be afraid to renegotiate. If you're in a contract, you've looked at your scope, you've looked at your terms, you see, you know what, this actually was not a very good idea to sign. Then don't be afraid to reach out to other parties and say, hey, we both know what's going on. Can we revisit this in lieu of our new environment? And if you do that, make sure to keep several scenarios in mind. So don't just have one idea of how you want this to go. Have several ideas of how you want this to go so that if one doesn't work, you have a backup and then you have another backup. And then, of course, keep in mind that best case is not necessarily going to be what you'll get in those situations. Look to non-traditional and creative solutions. It may be, I have a license agreement for some conference software, but I can't afford it anymore. Is there a way for me to split the license with several of my other colleagues or associations so that we can defray the costs? Then reaching out to the licensor to see if that's something that they would agree to. If I've rented a space that I can no longer use, but we said that we were going to do a concert series, is there a way that I can turn that virtual and still sell tickets and integrate the event or venue in some way so that they do get some money, but they may not get exactly what they were expecting when we first signed the contract. So just looking for different solutions. And then, of course, you know, when you're looking through your, well, we talked about this, so I won't spend too much time on it. No, we're running out of time. What I would really focus on probably right now is what are your gaps and the exposure they create when you're looking at your contracts. And is there language in there that would have been helpful that isn't included so that as you start to renegotiate and create amendments to your contracts, you can include that language and bolster them up a little bit more. Or, you know, think about language that exposes, if there's a language that exposes a party to certain liability, is that something that can be removed in your renegotiation? So if you saw language that you're like, ooh, kind of wish that wasn't in there, when you do your renegotiations, is that something that you can have taken out? So before I go to mitigating, I see that there's a quick question. I'll see. Okay, so actually I'll address this question right after I go through this. So in terms of mitigating, like I said, revising your contract management process, thinking about your operations, really empowering your employees. What I would do with a lot of the corporations that I work with is we create contract playbooks. And I would have several different provisions for, so I may have a warranty section, and then I would have several different provisions that I drafted so that employees could pick and choose. And then we would do education for the employees to give them a better understanding of this is where you would use this is where you would use this language. They would have a script so that they would be able to explain things like indemnity. But I think that's really important because there's going to be so much change and so much movement over the next couple of months and years. And so having all that run to the top is probably going to become really difficult for some organizations. To that end, renegotiate and issue amendments if need be, put resolution processes in place. So that's where we're avoiding being a booger and finding ways to address situations outside of adversarialness. And then also just changing up operations possibly to limit some of our risk moving forward. So the question that I got, which kind of goes into things to consider, was we have made updates within our addendums with hotel contracts for this year. This year, due to the quick changes, we've been lucky with our revisions to existing contracts with hotels, but we've been told we cannot count on hotels being as flexible in 2021. Are there any thoughts on that around COVID-19 ongoing changes and issues? So perfect for this section, because yes, one of the things, I don't know if I have this in here, that I've heard, for example, is people are going to start using the word unforeseeable in force majeure. That really changes that language, right? Because what they're going to say is, what they're trying to do is say, moving forward, COVID is not unforeseeable, or the impacts of COVID are not unforeseeable. So that's something that you want, one, to answer your question, you want to really be reading these agreements. I've worked with organizations across the spectrum in terms of size, so I know that that can be tricky, especially for smaller ones. But there's people that are going to get really sneaky with language right now. And so in terms of things to be thinking about for 2021, one of them is just reading the language, making sure you understand the language. You may not have an attorney draft the agreement, and you may not even have them negotiated, but at the very least, you might have them read it. I do plenty of that for a lot of my small businesses, where they just say, hey, I want to make sure that I'm not going to lose myself here in this agreement. And what I'll do is I'll mark up and say, this is something that you may want to think about. This may not be that big of a deal, knowing the work you do. So that may be something else to think about as your processes for contract review in 2021. And then also, this is where relationships again comes into play, and having those relationships with those hotels, having the frank and somewhat difficult conversations around what you're facing in 2021, and giving them context, because they're going to be thinking it from their perspective. But those are some of the things off the top of my mind that I would be thinking about. And it goes to this slide, and then I don't know if we're kind of at time, but happy to answer any other questions if we have them. The reason I typically see issues in contract negotiations, or just contracts in general, is people don't feel heard, they don't feel acknowledged, they feel taken advantage of, or they feel like you're being selfish. So what we have to remember, and this goes to the question about the hotels in 2021, what we have to remember is that we're negotiating with people. And because we're negotiating with people, we have to keep in mind they've got feelings, they've got families, they got challenges, and all of that needs to be considered when we're negotiating with them. So it's not just the matter of a document. It's, again, it goes back to that relationship and making sure that we're acknowledging the individuals on the other side of the table. I had parting thoughts in terms of just making sure that as you move forward, you stay experimental. So again, you may need to change your processes in terms of how you review contracts. You may need to change up your operations to limit some of your liability. And so when you get the slides, you'll see just a little graphic that I had around ways to create more experimental cultures in your organizations. Yes, I am saying get experimental with your contracts. I know that's not something attorneys tend to say. I know we're a couple minutes over, but there were 2 questions. If you wanted to shoot those over, I'm totally fine with it. If not, I'm happy to answer offline. Just let me know. Okay, so it looks like we're going to get those questions. I'll read them. Oh, I guess we're going to read them out loud, and then I'm happy to give answers.
Thank you. The question is, if I'm a third party but no longer working with a client and have a hotel contract with commission due to me, what is my ability to receive that commission if the ex-client renegotiates the contract because of force majeure?
Ooh, that's tricky. So do I mean that one more time, Regina?
Okay, so if I'm a third party and I'm no longer working with a client, but I have a hotel contract with commission due to me, what's my ability to receive that commission?
Uh-oh. I think I got it, Regina, on that one. So, oh, well, that's really tricky. So this is another one where it depends, which I know was probably not the answer wanted. What is my ability to receive that commission if the ex-client renegotiates? This actually comes up quite a bit in like real estate contracts, if you can imagine, which is why they oftentimes have that provision in there that says that you cannot purchase or rent any of the properties that they've shown you within like the next 30 days or something like that. Or if you do, that they're entitled to their commission. And so one, this may be something to look at, is those contracts, to see if there's similar language that might need to be added to your agreements moving forward, because I imagine a lot of clients are going to be renegotiating their contracts. this is one that's probably going to rely heavily on relationships. I'm trying to think if there's provisions in there. Typically with the hotel contracts that I've reviewed, because it's between the two parties, one thing that you may end up looking at is the third party beneficiary language in that well, they would have to show you the agreement. So you may have rights to the third party beneficiary, even though you're a third party. It really just depends entirely on what their contract says. And that would be something that one of them would have to disclose. Unless it's something that was public. You may see something on a template if they signed a template. Typically, contracts will say there are no third-party beneficiaries, but that may be a way to get rights and enforcement that you didn't otherwise have. And then the other is just, as they renegotiate, to make yourself a party. And so you may create a definition around group that includes that client and then include yourself in the group. Or it may just be a three-party agreement to make sure that you don't get cut out in the future is what I can think of off the top of my head. But it's really tricky unless there was a specific provision in there that said that wouldn't be able to happen. Well, I thank you so much for your questions. I know we had a little bit of technical difficulty, but hopefully this was insightful and illuminating. And if you do have any questions, because I know that I talked really fast, do feel free to reach out. This is the name of my practice, and then this is also my phone number if you need to get a hold of me.
Thank you so much, Erin. That was awesome. And I can promise you in the foreseeable future that we will be using the knowledge you shared with us today, and I'm pretty sure somebody is definitely going to reach out to you. So we really appreciate your time today. And we are going to now move into our special musical performance from Jen Out. And when we follow that with the video, we're going to take a little break and we're going to adjust the time for our technical difficulties. So instead of coming back at 3:10, we're going to come back at 3:15. So first Jen Out, then a break, returning at 3:15. And just a reminder, please participate in the community service project and thank our frontline workers during that time. Thank you so much, and we'll see you all again soon.